In the next 3 modules, we will explore 3 limitations that the law imposes on the recovery of contract damages: foreseeability, mitigation, and reasonable certainty. This module will focus on foreseeability using Hadley v. Baxendale. So let's begin with a reminder of terminology. We have learned that the non-breaching party is entitled to recover expectation damages, damages that aim to give that party the benefit of the bargain, most often as lost profits. This loss is embodied in the first element of the damage formula, loss in value. These damages are also referred to as direct damages. But we also saw that the non-breaching party is entitled to damages for other loss, the second element of the damage formula, often referred to as consequential damages. These damages relate not to the direct financial loss resulting from lost profit, but rather to other losses that flow from that breach. The law imposes limitations on the recovery of both direct and consequential damages. As a first limitation, the non-breaching party must prove that the harm incurred was in fact caused by the defendant's breach. But causation plays a less important role in contract law than it does tort law. Instead, foreseeability provides the most important limitation on the recovery of damages in contract law. In other words, there will be instances involving remote damages that were proximately caused by a breach, but which are not recoverable because they were not foreseeable. The limitation of foreseeability was first developed in the 19th century case of Hadley v. Baxendale, a case you can rest assured every first-year law student in the country is reading. According to that case, the non-breaching party is entitled to recover only those damages that the breaching party could reasonably foresee at the time of contracting as likely to result from a breach. This principle is set forth in Subpart 1 of Section 351 of the Restatement. Foreseeability is an objective standard that links the extent of damages recoverable to what a reasonable person in the position of the breaching party would realize at the time of contracting would be the likelihood of such damages accruing. Generally, direct damages, those that result in a loss of contractual value from the breach, are readily foreseeable and raise few issues. Every party understands that if it breaches a contract, it will be liable for the profits that the non-breaching party lost as a result of the breach. In contrast, foreseeability is a major issue when it comes to consequential damages. In Hadley v. Baxendale, the plaintiffs owned a mill that was halted by a broken crankshaft. They entered into a contract with the defendants, a railway shipping company, to carry the broken crankshaft to Greenwich to be used as a model for the construction of a replacement. Through defendants' neglect, the delivery of the crankshaft was delayed, and as a result, the mill remained shut down for several extra days. The plaintiff sought to recover the profit lost during that period. In Hadley v. Baxendale, the court established 2 rules related to foreseeability and contract damages. First, a non-breaching party plaintiff is entitled to recover all damages that it can prove occurred in the ordinary course of events as a result of the breach. These are often referred to as general damages. This rule is encompassed in Subpart 2A of Section 351 of the Restatement of Contracts. The second rule established by Hadley v. Baxendale concerns what have become known as special damages. The injured party is entitled to recover for contractual losses that did not occur in the ordinary course of events, but were the result of special circumstances of the non-breaching party. But such recovery is allowed only if the defendant had reason to know of those special circumstances at the time of contracting. This rule is encompassed in Subpart 2B of Section 351 of the Restatement of Contracts. Obviously, in many cases, whether or not special damages are recoverable will turn on the information concerning its special circumstances that the non-breaching party conveyed to the breaching party at the time of contracting. This is fair because it holds the breaching party liable for special damages only when that party was made aware during negotiations of the possibility of such damages occurring and had the opportunity to adjust the contract price accordingly. So let's consider an example that will help to distinguish between general damages and special damages. At the beginning of winter, Mary enters into a contract with Jane, whereby Jane agrees to plow Mary's driveway within 12 hours of the end of every snowstorm. After a particularly heavy snowstorm, Jane fails to show up for 36 hours. At that time, desperate to get to work, Mary hires Bill to plow her driveway. He charges $100 more than Jane. Moreover, as a result of Mary's not being able to get her car out of the garage, she missed the scheduled business meeting, which resulted in her losing a deal that would earn her a profit of $2 million. In terms of simple causation, Jane's breach of contract resulted both in Mary's having to pay an extra $100 to get her driveway plowed and losing $2 million in profit. But as noted above, however, causation alone is not determinative of the damages recoverable in contract law. The damages must have been foreseeable to the breaching party at the time of contracting. It's entirely foreseeable that Jane would incur the consequential damages resulting from having to hire another plowing company to clear a driveway in the event that Jane breached the contract. Such consequential damages fall within the realm of general damages. It is unlikely, however, that Jane could reasonably foresee that her breach would result in Mary's losing a $2 million business deal. Such damages are considered special damages because they do not occur in the ordinary course of events. As such, absent Mary's having informed Jane of the potential occurrence of such special damages, a court would not hold Jane liable for the damages. On the other hand, if, at the time of contracting, Mary had informed Jane that in the event it snowed on a particular date, it was mandatory that the driveway be plowed because of the necessity that she attend the closing of a $2 million business deal, a court might well hold Jane liable for such damages. In all likelihood, however, Jane would have refused to enter into such a risky contract, or else she would have charged an extraordinary premium to take on that risk. Requiring that special circumstances that might result in unusual damage be conveyed to the other party at the time of contracting is fair, because it assures that the breaching party take those circumstances into account when deciding whether or not to enter into the contract, and on what terms. In addition, the rule of Hadley v. Baxendale encourages every party to convey complete information about possible risks of damages to the other side to assure that it will be covered in the event of a breach of contract.